Attorney Ethan Bearman here, diving into the labyrinth of the law to shed light on the truths and falsehoods that often perplex the public. Today we're targeting some persistent legal myths, so prepare for a journey into the heart of legal reality as we dismantle these myths one by one. Myth number one: if the police don't read you your rights, your case is automatically dismissed. First up is this concept of Miranda rights. If you've watched TV at all, you've heard this thrown around. It's a cornerstone of criminal justice over the last 50 years. However, it's often misunderstood, and recent Supreme Court rulings are starting to change Miranda rights. It's the notion that failing to recite these rights nullifies an arrest. That's a dramatic oversimplification. In reality, the absence of a Miranda warning primarily affects the admissibilities of statements made during what's called a custodial interrogation. So there's nuance in the application of this law, and it really centers around this idea of a custodial interrogation. And what that means is, so for example, if you get pulled over at the side of the road, which the police officer has to have probable cause, you were speeding, your tail lights out, whatever that is, they come up, they absolutely have the right to say, I need to see your driver's license, your insurance information, you have to give them your name. You cannot hide that stuff. We've seen cases over the last few years where people get in trouble because they don't provide the basics. The police can ask you those basic questions. Anything beyond that, you don't necessarily have to answer. There are really specific circumstances there. But the Miranda warning doesn't apply to them asking you basic questions. If you're walking down the street, hey, what's your name? Where are you going? You don't have to answer anything beyond your basic identification. And that's, again, if they have probable cause. That is not a custodial interrogation. A custodial interrogation, generally speaking, means that the police have taken you somewhere, whether it's the back of their car, they're surrounding you on the street, you're not free to leave, and they're now asking you questions that are specific to circumstances. In those cases, you're not free to leave, and they're asking you for additional information beyond the basics of your identification. Generally speaking, again, now you're in a custodial interrogation. Hey, where were you on this night? What were you doing? Who were you with? And you're not free to leave. You're in an interrogation room. You're in the back of their car. You're any number of cases where, again, they're surrounding you and you're not free to go. That, generally speaking, is a custodial interrogation. They have to read you the Miranda rights. But also important regarding your Miranda rights is any statements that you make during this custodial interrogation automatically makes your case go away. That's not true. It just means it can't necessarily, and generally and almost exclusively meaning, they can't use those statements to show that you're guilty. But they still can use a statement that was gathered, even if with an improper Miranda warning, they still can use it to do something that's called impeach you, meaning show that you're lying about something. So it's really important to understand what those mean, and there's so much common misconception about it. All right, myth number two: you can't be charged with a crime if you didn't know it was illegal. I mean, this is the classic ignorance of the law is no excuse. Principle is old as law itself, yet frequently misused. The law presumes knowledge. We expect you to know the law, whether or not you know it. So that imposes a duty on you to be informed. It's a myth, and it's a serious folly. You need to be aware of what the law is, even if you think you don't need to be. I mean, again, a perfect example, let's use driving down the road, and the speed limit is 40. A mile back, it was 55, so you're still going 55, and now you're in a 40 zone. You get pulled over for speeding, and you're given a ticket for it. It's just that simple. But here's an important one. In the modern social media age, famous people have been caught with this. Simply using somebody else's photograph, for example, of you, and then reposting on your Instagram feed, for example, or use it in a TikTok or wherever you're going to use it, you have likely violated the photographer's copyright, or if they've sold their image to a company like Getty Images, even though you don't know copyright law, you will likely owe $15,000 to Getty Images or the photographer. They'll try and negotiate with you to get you to pay if you're not a wealthy individual. But the point is, your ignorance of copyright law doesn't mean you get to use this image and be free from the consequences of it. All right, myth number 3. A verbal agreement isn't legally binding. This is a wild one. I can't tell you how often I talk to people about this. This is the idea of a verbal agreement. Well, I didn't put it in writing. We just talked about something. Somebody made me an offer. I accepted it. I did the work. They didn't pay me. Well, they never put it in writing. That's an oral contract. Oral contracts are, generally speaking, enforceable. There are certain exceptions where it's not. And there's a whole section of law called the Statute of Frauds, for example, wherein certain agreements must be in writing. So when it deals with a lease, if you've ever rented an apartment or a house or bought a house, anything that relates to real property and has a longer than a 1-year term, it must be in writing. Things like marriages must be in writing. I mean, it's weird stuff. It goes way back in the law. But it is not uncommon that I will litigate even with my own clients over oral agreements. If somebody makes a promise to you and you rely on that promise and take action based on an offer, again, one of the most simple examples, hey, if you mow my lawn, I'll pay you $20. So now if you go and mow my lawn and I don't pay you $20, hey, it wasn't in writing, it doesn't matter. They made you an offer, you accepted the offer, you acted upon that offer, now they owe you the money of it. The other term in the law is what's called a BFE, benefit for exchange. They received a benefit in exchange, you did some work, that did it, and you were offered money, they owe you the $20. All right, myth, the next myth. The freedom of speech means you can say anything without consequences. Oh, I love this one. Our final myth today challenges the boundaries of free speech. The fundamental right, while robust, is not a carte blanche to harm, defame, or incite unlawfully. We'll dissect what this means here. There's a balance between liberty and responsibility, but most importantly, this idea of First Amendment rights has to do with, is the government interfering with your free speech? That's the fundamental misconception I've seen thrown around for a long time now. My First Amendment rights doesn't mean you get to come into my house, for example, or even my office, say whatever you want, do whatever you please. No, you're in private property. You don't get to be here and say whatever you want. And even on government property, as long as there isn't, I'm going to oversimplify here, but as long as the government isn't choosing whose speech they prefer. So if it's an equal application, so let's say you want to go stand in front of City Hall and protest. They don't get to say, what are you protesting? They get to say, here are the rules for protesting in front of City Hall, regardless of what it is that you're protesting about. You can only do it with a permit, and it's between the hours of 7 and 9, and it has to stay on the sidewalk. As long as it doesn't, the rules don't care about what it is you're talking about, and say, I prefer Christians over Muslims, or I prefer Democrats over Republicans, or I prefer whatever that is. The government doesn't get to make that preference. And that's what the First Amendment really, really does talk about. So you don't have an unlimited ability. But also going back to social media for a second, you don't get to defame people. Defamation, there's libel, there's slander. Slander is the spoken word, libel is the written word, roughly speaking. You don't get to say something that is objectively untrue about another person that harms them. Now, the problem is people think I can sue you for defamation because I said, you're ugly, I don't like you. That that's not objectively false. That's your opinion. Objectively false would be, for example, Donald Trump won the 2020 election. No, he didn't. Joe Biden did. And if you're going to present that information in an effort to harm somebody, for example, you molested that child and you know that's not true, but you make that allegation against somebody else and it causes them harm and they lose a job over it, or they lose their job over it, you're liable for defamation. Now, there's lots of rules around how we proceed with defamation cases in courts, but generally speaking, if you're saying something that is objectively false, provably false about somebody else, a business, a person, whatever, and it causes them harm, generally speaking, that falls under defamation. That is not a First Amendment protected right. So you have to be very careful about that. So in conclusion, these 4 legal myths I talked about today, though widespread, are simplifications of complex legal principles. Knowledge and understanding of the law do empower us to navigate our society more effectively. I encourage you to delve deeper, question commonly held beliefs, and always seek professional, licensed legal advice in your jurisdiction when needed. So thank you so much for joining me in this legal myth-busting journey. If you found this enlightening, like, subscribe, share your thoughts or questions in the comments, and stay tuned for more legal insights in our next episode. Thank you.